probably be ducking out pretty quickly too. So don't let me interrupt or disturb anything.
Art, do you want to kick us off?
We ready?
Yeah.
Sounds good. Hi, my name is Bart Hutchinson. I'm the Chief Labor and Safety Inspector for the Division of Bureau of Labor Standards, Wage and Hour Division. I'm experienced in the funeral home business. My dad was a funeral director for many years in Maine and Massachusetts, owned and operated and managed a lot of different homes over the years. And as a result, as all sons do, entered the field or dabbled in the field for a little while. My brother actually was a licensed funeral director for a number of years. We're all out of the business now. But what it does do is allow me to have an awful lot of insight in the funeral business that the average person wouldn't have. Number one is the sense of humor that tends to go with it, that the lay people have no knowledge of. So what I'd like to do is I'm going to share my screen and we're going to go down through and hit some highlights of what is there. Are you folks seeing? Well, hold on. You should be seeing a cover sheet, Maine employment law. That there, perfect. Okay, I am not Steve Spencer. I grabbed his presentation because it includes what I need for this without making a bunch of alterations to it. Okay, so we go down. Wage and hour, we do a lot of different things. We do from posters, human trafficking, minimum wage, overtime, timely payment of wage, overcompensation, just about anything that has to do with payroll. We have a hand in it. There's 96 statutes that we actually enforce. You've got two groups that can inspect you for wage and hour issues. One of them is Maine jurisdiction, Maine DOL, wage and hour, or US DOL. Because of the volume, sales volume of most funeral homes, you're going to fall under the jurisdiction of US DOL as well as Maine. And our jurisdiction will cover from any employer that has one or more employees. We don't need to worry about this. EPL, if you have 10 or more employees in the state of Maine, you're required to have EPL, earned paid leave. And if you have questions about that or you've got it established and you're still a little confused, don't worry about reaching out to us. We'll help you get through that process. But that is going to be 10 or more employees. Non-compete. Most funeral homes are going to be in a position where they will meet the $51,000 annual salary. The trick here is, though, what's going to catch you is you can't prevent a funeral director from opening a shop down the street. You know, there are no trade secrets here. We're all doing the same thing. The difference is what casket brand we're selling, what crematory or tort we're using. But for the most part, you're not going to be able to get into a restrictive hiring agreement with a funeral director, much like a hairdresser. From one shop to the next shop, we're doing the same standard things. We do have the authority to shut down a business if they have a record of wage theft. It's something that we exercise very carefully. I have to be sold by my inspectors. I then have to sell the chain of command that we want to pursue this, and it's something we take very seriously before we ever get to that point. When you're in the hiring process, you don't ask about their social security number. Once you hire them, you're going to have to ask for it. But during that process, you want to leave the social security number right out. Same with criminal history. You're not going to find too many guys going into this field with criminal history, but if you do, you see that big gap in the resume, you want to give them an opportunity to explain what the gap is. If they say, well, I might have spent some time in the county Hilton there, give them an opportunity to explain the circumstances. And you want to document that opportunity that you gave them so it doesn't come back around later to get you. Labor posters, don't buy labor posters. We have them online free of charge. They can be color, they can be black and white. Those purchased ones will look really great, but you don't need to buy them. They're free from us. And you'll want those posted somewheres in the break room, in the back kitchen, the embalming room, the garage, somewhere where they can look at it without having to go into the manager's office and say, yeah, excuse me, I got to look at the poster here. As an intern, you're going to want to keep true and accurate records for these employees. Those need to be kept for a period of 3 years for our purposes. And that will show when they start at the day, when they end at the day. You'll want to document how lunch is dealt with. If it's a paid lunch, you want to have that documented, that we do a paid lunch. It's from 12 to 12:30 on most days. If it's an unpaid lunch, you're going to want to have them punch out and note that lunch. So that way you're able to, hopefully we never get a call, but if we do get a call, we'd be looking at those break periods being shown, or what is the policy on the break period. And then pay stubs. I've never had a funeral home with a pay stub issue, but ultimately you have to have hours worked on the pay stub and the gross pay. You don't have to actually show the wage per hour, but you do need hours worked on that pay stub. Two numbers come to mind right here that you really need to watch. For your salary exempt employees, and we'll explain what are salary exempt employees, they need to be meeting at least $735.59. So $7.36 an hour for your salary exempt employees. That's not going to be a problem in the funeral business. And then the next number that you're going to want to watch for your interns is $12.75. Can't get below that. For the hourly employees, any hours over 40 are going to be overtime. So it's going to be time and a half. You've got your time clock running or your time records running. The bookkeeper or the funeral home manager needs to be looking or keeping track of what those hours are. There is nothing that prevents you from flexing the hours. So I'm working for you. My schedule is Monday through Friday, 8 to 5 with an hour lunch, unpaid lunch. It's perfectly fine. But remember, we typically run funerals on Saturdays. So that means you're going to end up with overtime on that day. There's nothing that prevents you from flexing it and say, I'd rather you work Tuesday and through Saturday. That way you've eliminated at least 8 hours potentially of overtime. Saturday could end up overtime if it was a late day, but you also have calling hours during the course of the week. And you also have removals that are going to be in there that are going to count as overtime or against overtime. So the ability to flex those hours, it's the employer's right to fix the schedule. And that can be a moving schedule and moving hours based upon the company needs. Most of us, you think in the funeral business and I'm working 8 to 5. Well, it's not really how it works. It's a round the clock job oftentimes. Minimum work week, you're going to establish your work week. Usually it'll be Sunday to Saturday. In commercial restaurants, they typically run Wednesday or Thursday as their start, and they run back around to either the Tuesday or Wednesday of the following week. The whole purpose of that is to control their overtime. And this may not be a bad idea in the funeral business just because of how Saturdays, Sundays, and removals or nights play out. You may want to explore pulling off of the Saturday, either the Sunday or the Monday start, and going to a Wednesday. If you're doing a lot of work on Saturday, you want that to kind of include, and then you can turn around and cut the hours on a Monday or Tuesday, which would be the end of your work week. Not the end of someone's usual week, but it would be the end of your work week. So you can control your overtime costs there. And then overtime is always counted on the 7-day work cycle. So at no point in time can we reach our 40. We've now worked 46. Take those 6 hours. I'm going to roll those into the next work week and not have to pay overtime. Every week stands alone, and it's a 7-day cycle for the purpose of overtime. Regular rate, don't need to get too far into this. Usually it's going to be the hourly rate that you establish. Is going to include the payout that you may have for removals. It's the payout that you may have, or the stipend, whatever you want to call it, for calling hours, driving the, I don't know if you have flower cars, it's kind of old nowadays, but if you drive, if you're just the driver or you're just the door dressing, you're not really working the funeral, but you're standing there just greeting guests because you've got other funeral directors doing whatever, and you set that bonus rate to work or assist, those all go towards the regular rate for the purpose of establishing overtime. There are some exclusions. You can exclude gifts. We call it gifted income. Discretionary bonuses. That is the bonus where the Christmas bonus can be a discretionary bonus based upon the expectation of the employer and employee. If you give out a bonus every single Christmas, then it becomes habit and becomes almost non-discretionary because it's expected. On the other side, if business is doing well and it's been a real rough week and you wanted to, share the wealth with the employees, whether it's gift cards to a restaurant, or a lot of manufacturing plants will do gas cards. The employee didn't expect it. The owner gave it out strictly as I'm in a giving mood and I'm going to share this. That's a non-discretionary bonus, so that won't count towards overtime. And if you get into some monies that you have that you're a little confused about, don't hesitate to give us a call and we can work down through what kind of how that money can count or not count towards overtime. Overtime, pretty straightforward. Anything over 40, it's going to be time and a half at that time and a half rate. If we get involved, or USDOL gets involved, we often talk about the half-time rate. It's strictly it's a business jargon, but we're looking at time and a half for anything over 40. You do run into questions with employees, or you're trying to figure out different ways of establishing your payroll with overtime, and how does overtime work and how does bonuses work. USDOL has a great overtime calculator that will, you can sit there, you hit the radial button, you enter in some quick information, and it'll give you a good example of exactly what you're trying to do and what are the outside costs or the ultimate costs of that. I have employers use that to help employees understand how they're paid overtime when it's a really convoluted system. USDOL did real well at establishing that. Okay, multiple rates. I guess you could get into a multiple rate in the funeral business. 8 to 5, I'm going to pay you X number of dollars. Evenings, I'm going to pay you, a different rate. If that's the case, then you would use the multiple hourly rate formula to create your overtime. It's called a weighted average. A lot of businesses just take the highest rate and run their overtime at the highest rate because it's easier than doing the math to actually get the true wage owed. But there is the ability to do a multiple rate overtime. Bonuses, if you're doing, take a funeral home and you've got sales, an actual sales person per se, a funeral director that specializes in sales, and they've got some commission base to it, you need to be aware that those commissions or bonuses do affect the overtime rate for that time period that the bonus represents. So if you're doing quarterly, then you would need to go back and look at the last 3 months. And any overtime that was worked would need to be adjusted, and you would probably owe money based on the bonus that they received. I suggest to a lot of businesses, if you're going to do bonuses, do them as close to weekly, bi-weekly as you can, so you're not looking over a long period of time to see what effect that bonus has. Tipped employees, we don't do that. Okay. Now we're going to get into the fun part. So in the funeral business, everybody seemed to work salary. And unfortunately, the vast majority of the funeral directors do not meet salary exempt status. The duties test to be salary exempt is you either need to be administrative and meet that definition, or an executive to meet the definition. A funeral director will never meet the professional standard because you have to have an advanced degree in science or learning. And to be a funeral director, you don't meet the standard for the advanced degree. We're talking doctors, lawyers, chemists of master's degrees and beyond to get that standard, which kind of creates a problem because funeral directors are professional. They just don't meet that standard. They don't get there. So the next step that you have to meet is the executive or administrative. The funeral home manager that has 2 or more employees under him will meet the executive branch because of the 2 or more employees. That's pretty cut and dry. If you are a 1 or 2 person shop, you're not going to meet the executive branch exemption. You may meet the administrative branch on a 1 or 2 person shop, but the average funeral director will not meet administrative, because to meet that standard, they need to be in a position to make significant financial decisions for the funeral home. And when we're talking significant, we're talking they can turn around on their own and completely change what brand of casket that they're now going to be using from that point forward. They're in a position to make the decision and sign off on the hiring of a new employee or the acquisition of a new building. So these are significant decisions that need to be made that the typical funeral director is not making. They are operating, a typical funeral director is operating within the script and policies that the company has established. What crematory they're using, what casket that they're selling, the services that are offered, the scale of pay or charges for those particular services. They don't have the freedom to go out and beyond and go rogue. Otherwise, the business isn't making money. So the typical funeral director will not meet the standard for administrative. Let's back up one. So what that means is the average funeral director is an hourly employee, which is really against how I was raised and how most funeral homes probably view it. But if you don't review your funeral directors and how they're being paid, and if they are salary exempt now and it's incorrect, you need to get them straightened out. Because if USDOL or Maine DOL comes in and finds that you've misclassified your funeral directors, then you lose the right to the exemption from that point forward. So no matter what you did to try to get them into compliance, you would lose that right and you could not have salary exempt employees at that funeral home. So it's imperative that you do that self-evaluation and determine, do they meet the standard or not? Because there's a lot to lose by having them incorrectly classified. You can find that information on USDOL fact sheet 17A that gives you definitions. And then from 17A, it drops down into a series of other definitions that will break down the executive branch even more, the administrative branch. And you need to meet all of those standards for that salary exemption. So it's not just meeting one, you need to meet all. I can't stress enough, every business needs to evaluate their salary exempt employees to make sure that they're meeting the standard. And can stand an audit from either department. All right, because so if we roll in, we find a funeral director that's been misclassified, you are then liable for any of the overtime that he's worked for up to a 3-year period. There are times in the funeral business where that will definitely, you'll feel the pinch, and other times where it's like, well, we've made the mistake, we need to make the correction. But a lot of small businesses aren't in the position to be able to write a check for overtime that's been allowed to run wild incorrectly. Once you have your salary exempt employee, which is typically going to be your funeral home manager, because he's going to have a number of employees below him, the business can make certain deductions from his salary. Most of the time, the deductions can come in the first and last week of work. You hire him and he's only worked 3 days, you could in theory dock him 2 days. Or the last week of his employment, he leaves on a Wednesday, there again, you could dock him for another 2 days. But most absences are going to be paid just by the sake of what salary exempt is. If you've got a sick policy in place and they've exhausted all their accrued time, you can dock them a day, but you've got to go and have that documented. You want to make sure it's clearly documented. Full day absences for personal reasons. They can't give you a good reason why they're out. Probably dock their day. But those managers, you want to figure out, am I docking the day? Because they're probably going to end up working an evening for calling hours down the road. But if you get into trying to figure out how you can make deductions from salary, let us know and we'll work down through that with you. There's lots of twists and turns to it. But at no point in time can you make a deduction that is, if I've worked 1 hour in the day, then I've worked the day as salary exempt. So you can't make half-day deductions. They're either full-day deductions or nothing. And the moment I've worked 1 hour, it's a full day salary. Timely payment of wage is something that the industry needs to watch. All hourly employees are on really 2 pay cycles. They're either paid weekly or they're paid bi-weekly. There is a semi-monthly program or payment ability, but almost every semi-monthly payroll process that I have seen has been in violation of labor law. Weekly and bi-weekly, it's really easy to stay in compliance with that. The key thing here is when you get a chance, look at your pay stub. It's going to say, you're paid on the 11th of March. You need count back 8 days, and March 3rd should be part of that pay cycle. If it's not, then you're beyond the 8 days of payment, and you need to adjust your payroll to include the 8 days. Most payroll companies catch this real quick and get you right into compliance. But if you have questions, reach out to us. We kind of like to use the safe harbors. You reach out to us, say, hey, this is what I've got. How do I fix it? We're going to work with you and get you through it. Opposed to if an employee calls up and says, hey, I haven't got paid timely for 3 years. Well, now we're unfortunately in your house, and we've got to address the problem at that point in time. But we're certainly willing to help employers get these things corrected when they find their problems, so we don't have issues down the road. And then this is just timely payment of wage. If you're going to increase someone's pay dates, so you're going to go from weekly to bi-weekly, you got to give them 30 days notice. Anything that's adverse to their pay needs to be within 30 days, or give a 30-day notice. On the other hand, if you were to decrease someone's pay, an employee that's just not working out right, instead of doing part of that progressive plan, discipline plan could be to reduce their wage, you can give them 1 day notice. Let them know right up front. Effective tomorrow, your new rate is going to be this. And that is perfectly well within standards to do that. Don't have those guys. Your cessation of employment, so an employee leaves. 2 things: vacation pay, if you are paying it out, it is treated as wages, so it needs to be paid out at the next established pay date. There's a number of expenses that typically come in when you have a funeral home or funeral director, intern, student coming into the business. You want to have a well-established agreement. If the funeral home is actually fronting the pay, the cost of schooling, you want to have a plan and have that well-established. How long do they need to work with you before that outstanding balance is paid for? There's no way to capture an agreement if it's not out on paper, and it can be legal and binding. So you want to clearly have that established, what the expectations are for that particular new employee coming in. Or I guess it could be an older employee coming back into the field. I'm so far removed, I don't know if they end up going as a funeral home attendant first before they can get fully licensed again, or if they need to retest and there's costs to that. But you want to establish those costs at the very beginning and get them in writing, so that at departure, if there is a problem, you've got something to lean on. And if there's confusion as to what can be charged back to the employee, give us a call and we can work with that. Overcompensation. Let's say you get an employee that somehow somebody during payroll fat-fingered payroll and paid the employee more than they were supposed to be paid. You got 2 choices. Hopefully the first one is you reach out and you talk to the director and say, hey, you got an extra 1,000 last week. I don't know if you noticed. Most employees are probably going to say no. Some of them will come right to you and say, if they're really on top of their payroll or their pay stubs and banking accounts, they'll know what's happened. But they're a group like me that I do not balance my checkbook, and I don't look at my balance in my checkbook. I know exactly what's in there from what I am accustomed to, and I know what's going out. So it's always in my head. If you were to drop an extra $500 or $1,000 in there, it might be a while before I ever noticed that there was anything different in there because it's not something that I'm planning for. So you may, when you approach that employee and say, listen, we paid you extra last week and we need to get it back. It could be generally a surprise to them that's in there because they have not seen it. At that point in time, you need to make it. You're going to try to make a conversation or an agreement with them that the next payroll cycle you're taking it back. You get some kind of a written agreement to get it back from them. And a good employee will work with you on that because they know it's not their money. If they decide not to work with you, then your next step is to go and be able to take 5% of the net out every week. They can't prevent that. That's your legal right to collect at 5% of net until that overpayment is paid out or made whole. You'll want to go and create some type of an Excel worksheet so that you can track it and they know how that payout is going. Otherwise, we'll end up with a phone call and they'll be complaining that you're taking more than 5%. Share that Excel worksheet with them. But most employees will work with you with a written agreement. You paid me over 500, great. Take 500 out of the next paycheck, or take 100 for the next 5 weeks, whatever it works out. Get that in writing. You, as a private industry, you can't use comp time. Comp time would be, I worked 45 hours this week, the 7-day cycle. I'm going to take 5 hours and bank it. Private sector is not allowed to do that. It has to be paid out. The alternative is you could flex their hours. If you modify your pay cycles to start on Wednesday of the week, Wednesday to Tuesday, that would give you Sunday, Monday, Tuesday, which might be your slower days, to flex those hours and say, hey, take next Tuesday off, or only work 3 hours on Tuesday to get you to the 40. But you can't use comp time. That is a public sector, I want to call it a benefit, but only public sector can use it. And it creates its own problems in public sector with comp time as it is. So stay away from comp time. You can't float overtime into the coming week and shorten their work week. You can't allow an employee to work without compensation. That's where I end up getting involved oftentimes. A business is not paying their employees. It's now come up to Thursday and the employees get word they're not getting paid again. If I'm in the neighborhood or one of my inspectors are in the neighborhood, we're going in and we're sending the employees home. You can't allow them to work without compensation. It's wage theft clearly at that point in time. You can't deduct from an employee's pay costs that are part of doing business. They're moving a casket from the second floor to the first floor. Someone trips and falls and the casket gets damaged. That's a cost of doing business. It's not a deliberate act. They're backing up in the garage. They catch the mirror. All the little things that can happen and go wrong in business goes wrong in the funeral home as well. Those are costs of doing business. If you find that you have an employee that deliberately backed the hearse into the telephone pole out of spite or anger, it's a criminal act. You still can't affect his wages. You have to pay him because he did it while he was working. So you're going to have to pay him out those hours. But you would then turn around and contact the local police department because now it's criminal mischief. But it cannot affect the deliberate acts cannot affect their wages, nor can the cost of doing business. You need to keep those, it's hard when an employee deliberately destroys something, but you need to keep it separate because that's now a criminal act and it can't affect the wages. Hopefully you guys don't see a lot of these, but the court-ordered garnishments, the only thing I can say there is when you do a court order, when you receive a court-ordered garnishment, make sure it's truly from an agency. It's either going to be the IRS, it's going to be a court. I had an employer call a couple of months back with a letter of garnishment from an attorney's office. The attorney was reaching for the stars, trying to get money sent to them directly under a garnishment agreement that had no legal binding. So just be aware, it's going to come from the state of Maine, the federal government, certain court system, the IRS. And if you get a questionable one, question it. Last thing you want to do is find out you've been garnishing this guy or girl illegally and they come back on you. Even though it may look good on paper, you want to verify. Okay. At no point in time can an employee or employer exempt one another from any labor law. So you're bringing on that new intern and you or they offer up a really good deal. You want to make sure you're not violating labor law, because the employee can never be found in violation. It's always going to be the employer. Even though the employee may agree to do it, it's going to be the employer that's going to pay the price. So don't get into unfair agreements. We see a lot of them in a lot of different industries where it sounded like a good deal and everybody was happy until either US DOL or Maine DOL ended up in the middle of it. And we realized, yeah, that was a bad agreement. It's going to cost somebody a lot of money to get squared away. Now, rest breaks, funeral business, it's part of the deal. Your hourly employees are required, or the employers are required, to recognize 6 hours of consecutive work equals a 30-minute unpaid break or paid break. That 30 minutes can be had at any point in time during the course of the shift. So once they hit 6 hours, it doesn't mean a 30-minute break. Think of Hannaford and Shaw's. They're giving breaks throughout the day to their employees, regardless of where they are on the schedule. They just know they're going to be working more than 6 hours, or the schedule for more than 6 hours. We need to get our breaks in. The funeral business, a little different, a little bit more laid back on some days, and other days you're working right through lunch. But you want to make sure that you're getting that lunch break or giving that opportunity for the lunch break in. Key thing to remember here, though, is any break that is less than 20 minutes is a paid break. So any break that's 20 minutes or less is a paid break. That becomes a problem in telemarketing companies and businesses that, let's say dental offices, where they're in between patients quite a bit. You got 20 minutes or you got 15 minutes between the break, punch out. No, that's work time. So the funeral business, I don't see that would be a problem very often. But you want to be conscious of that 30-minute requirement for employees. Child labor, I'm going to tell you, my dad, he was a violator of it. I did a lot of mowing of lawns at the funeral home. You can't have children working there. If you're going to end up with children working, even if they're your own, 14, 15-year-olds have to have a work permit. There are hazardous duties that are listed by US DOL that you need to follow. If you're thinking of hiring minors to do whatever, it could be cleaning. It could be raking of leaves in the fall, or sweeping the driveways. Give us a call. I've got a labor inspector that her whole focus in life is child labor. She lives and breathes it. She will definitely help you out in what they can do and what they can't do, and the different ages that they can do it or can't do it. As I said, I did a lot of mowing of lawns. Once you're on you can have your child mowing your own lawn, but once you put it onto the business lawn, now you're under child labor laws. You want to make sure that you're not in violation there. Work permits. Okay. So why don't we, I'm not sure how long I've gone, but why don't we open it up to some questions? If anybody has some questions.
Hi, Bart. Thank you. It looks like we have 2 questions in the chat. I think the first one was answered about how many hours must an employee work before they are entitled to a break. So if there's a follow-up, please feel free to follow up. The second question has to do with exempt employees. Does the difference between administrative and executive have something to do with supervisory duties?
Correct. Executive needs to be able to oversee 2 or more employees. And that's where some of the confusion comes in. You think executive, well, you're going to be the chief operating financial officer. Well, if that chief operating officer, financial officer has no one underneath him, then he's not an executive. And you can title someone anything you want to title it. They can be manager, they can be supervisor, they can be CFO, but you need to determine the title doesn't matter. It really comes down to the role. So chief financial officer in most industry, unless they have multiple sites, would not meet the executive salary exam, even though they're an executive within the business. They're not going to meet the exemption standard. They may meet in that position the administrative, because as a CFO, you are making significant financial decisions from who the healthcare provider is going to be, what our dental plan is going to look like, how are we going to heat this building, and who are we going to use, and then sign off on those contracts that you've established. So the CFO could certainly be administrative, even though the world of business would look at them as an executive. So executive and administrative do not meet typically the definition of what the business world sees you as. Most HR specialists, we get into them and we find that they are listed as administrative. Most HR specialists are following the policies that are already established within the industry or within the business. These employees get X number of dollars an hour. They aren't in a position to do significant hiring and firing and reprimanding and such. They're really following the rules that are already established. The HR manager is in a position to be executive. They're overseeing 2 or more employees, but the HR staff below that is strictly following the script that they're provided. So they're not in a position to be able to be administrative. They don't have that latitude to make significant business decisions. So they need to be hourly. That comes to a shock to a lot of HR specialists, because you think, well, I'm doing administrative work, I must be administrative. Definitely the wrong direction to go down. You need to look at the individual roles and responsibilities for each position and see where does it meet executive, where does it meet administrative. If it doesn't meet those, or it's very gray, pull them down to hourly and play it safe.
Thank you. And if anyone has any questions, we have just under 10 minutes left, so please feel free to unmute or type in the chat, and I'm happy to share them.
So my brother, he was licensed back in the 2000s. Yeah, he would have been the 2000s. And he worked in Western Maine. And then he moved to Boston. And he also worked in Connecticut. And eventually moved out to Utah. And he and I were talking a couple of weeks ago about this presentation coming up. And he goes, do you realize It took me all the way to Utah before I was actually ever classified correctly as hourly plus overtime. He goes, I had worked years in the business and never received overtime. He goes, he didn't know that it was wrong. And if you don't ask, and most funeral directors, especially the new ones, and if they're going to school, they're probably being told you're going to have a great salary. Well, they land and they get the job and they go, I got a salary. It seems great. This must be life. And they don't have any knowledge that they're misclassified. Under Maine law, a misclassified employee, each employee counts as one violation. And that fine can be from $2,000 to $10,000 for wage and hour. It turns around that unemployment tax can fine you as well, because they have their own misclassification, not definition, the definition's the same, but they have their own fine process. So it's actually, and we try not to do it because it's a double hit, but state law allows both agencies to fine the employer twice for the same violation under totally separate statutes. So, our fine, 2,000 to 10,000, it's significant. We work very hard to educate employers to get to eliminate misclassification in industry, because it can be a significant hit to an employer. That not only do you end up with the potential for penalty from our side, but you also end up with the back pay for all the overtime that employee would have worked while they were misclassified potentially.
And it looks like we have another question. Could you touch on the criminal background checks again? I ran into this issue with trying to post a job on Indeed. They say that you can't ask about a criminal background check. However, to obtain a license, you have to pass a background check.
Okay. So, criminal background, we have ban the box, which means you can't ask on your application, do you have a criminal background? Okay. You get into the application process, you can ask it. You can ask for the hole in their resume. But on the other hand, you're restricted from asking for a social security number on the application. But for a background check, you need to have a social security number. So if you've got an applicant that is looking like he's heading down the path of being a potential employee, you'll need to do that background check. You'll need to ask for the social security number. At that same time, you're going to want to have that conversation. Is there anything that's going to show up that isn't going to be putting you in a good light? I'd rather know about it now, because I don't want to spend a bunch of money and time. Give them an opportunity. It may be, I got picked up for scooping some cigarettes when I was a teenager. That will probably show up as theft on their background check. They're now 27. They've gone to college, or they've got some education underneath them. They want to enter the field of funeral home, the funeral sciences. At that point in time, as an employer, you need to figure out, am I going to go down this path? Have they matured? Was it something they did as a minor? So that background check, as part of their licensing, you're going to need to do one, but you can't ask for it on the application. You need to get into the interview to actually have that discussion. Same with the social security number. Once you decide that, okay, we're going to go down this path and offer potential employment, we're going to do a background check. Now I need the social security number as well. Another thing that you need to be aware of is you can't ask a new applicant what their previous compensation is during the hiring process. So you got a funeral director that's left one funeral home or is looking to leave and wants to go to another one. You can't ask them, well, what did you make? What are you making now? You need to make an offer. Once the offer is made, then you can turn around and ask, so what were you making at XYZ? And they'll say, whatever, and you'll either be above or below that. But you need to make the offer before you ask about compensation history.
Can you
Thank
ask
you.
them what they're, can you
Go
ask
ahead.
them what they're looking for a salary?
You
Or,
certainly,
excuse, an hourly rate, not salary?
right, yep. You can certainly say, what range are we looking at? You can ask that. You just can't
Okay.
nail them down and say, so what were you at? 27, 35, 45? Or you could ask them, well, I was making 70,000 a year. I was salary exempt. You're gonna go, well, you're not gonna be that when you're here.
Oh, I've had that.
Oh, yeah, yeah. I have a background in law enforcement, spent a number of years in law enforcement. I then went private sector. So I have held every imaginable pay system that's out there. Negotiation is fun. I love to negotiate. I came to the state and realized they don't negotiate. That was rough for me, but you want to be real careful about asking about that compensation history. If you ask, what are you expecting? It's a far safer answer or question.
And we are about at time. So Bart, if anyone has any questions that's either on the call now or that wasn't able to attend, can you direct them as to, if there's a website or contact information as to where they could go?
Yep. The jump to the beginning. It would have been easy to jump to the back. Okay. So right down here, we've got 623-7900. That number is manned 8 to 5 every day that the state's all open by a labor safety inspector. Each one of them has a day they have to do. They answer questions from employers, from employees, from potential of both. They're here to help you out, get you down. I've got this employee. I'm not sure if they meet salary exempt. You want to have a quick conversation, great. They also are great for picking up tips. Employer XYZ, I heard, is doing something wrong. They're going to go and gather up that information so they can give it to the appropriate inspector to try to get ahead of the problem. The other thing is, let me give you an email address. My email address is bartlett.hutchinson, and it's BARTLETT.Hutchinson, HUTCHINSON @maine.gov. Drop me an email if you got questions. I'll try to answer them by email, but oftentimes I actually pick up the phone because there's usually more to the question, or I need more detail to give a good answer to help you out. Our goal here is to educate and do outreach. And I'd like to say that enforcement is secondary. That's what we want. Much rather work with employers and bring them into compliance and identify where their liabilities are ahead of time. It's a lot easier for us and for the employer that way. And I guess in a parting note, when an employee comes to you and has a problem, address it. Don't make the HR problem a labor problem, because if they're not satisfied or not squared away when they come to approach you, oftentimes they're reaching out to every state agency that's out there. because they're mad, or they've left the company on bad terms. And I often say, I think they opened the phone book and they started A and worked their way through Z, calling all the different agencies. But when an employer comes to you, when an employee comes to you with, and they don't understand how they're getting paid, take the time, explain it to them and why they're getting paid that way. You know, make that HR problem stop there and don't allow it to become a labor issue down the road.
Well, I think we're at time. So thank you so much, Bart, for the presentation. Thank you, everyone who is able to join us. And we will be posting this and we can send out a link to the video afterwards. And I think Linda will probably send that communication out. So once it's posted, we'll be able to send that out.
Thank you.
Thank
Thank
you.
you.
Thank you, everyone.
Thank you very much, Bart.
You're welcome. Bye-bye.